The Supreme Court just dropped a 90 unanimous ruling that nobody is talking about, and it changes everything about how police can take your guns. 9 justices, 0 disagreement. That almost never happens in a court as divided as this one. This ruling strikes at both the Second Amendment and the Fourth Amendment at the exact same time, which means your right to keep your guns and your right to be free from illegal searches just got a massive boost all at once. If you own a firearm, if you keep one in your home for protection, you need to stay right here because this affects you directly. The case is called Kiglia v. Stroh, and the Supreme Court of the United States decided it on May 17, 2021. For years before this ruling, police departments across the country were using something called the community caretaking exception to walk into people's homes and take their guns without a warrant. That phrase sounds harmless enough, but it had quietly become a backdoor tool to strip gun owners of their legally owned firearms with 0 judicial oversight, and the highest court in the land just shut it down completely, 9-0, no dissent, not a single justice. Disagreed. The information I'm about to share could literally save your guns the next time police show up at your door. But first, are you subscribed? You're going to want notifications turned on for this one because legal updates like this are dropping constantly and you do not want to miss them. Tap that subscribe button right now before we go any further. Now let me tell you the story of Edward Kiglia because this case started with a real man in a real home on a real night, and the way it unfolded will genuinely make your jaw drop. Edward and his wife had a serious argument inside their home in Cranston, Rhode Island. Things got heated, emotions were running high. And Edward did something dramatic in the middle of the fight. He grabbed one of his handguns, put it on the kitchen table, and said to his wife, "Shoot me now and get it over with." Edward did not shoot anyone. Nobody got hurt, but his wife was frightened enough that she left the house that night, stayed somewhere else, and called police the following morning. When officers arrived, they assessed the situation and decided they needed to check on Edward's welfare. They spoke with him, brought him outside, and made him a deal. They told Edward that if he agreed to go to the hospital for a voluntary psychiatric evaluation, he could come back home afterward and everything would be fine. Edward agreed. He thought he was doing the right thing. He thought he was cooperating and that his cooperation would be respected. He got into that ambulance and went to the hospital, believing his home and his property would be waiting for him when he returned. Here's exactly what happened while Edward was gone. While he was sitting in that hospital doing exactly what police asked him to do, the officers went back to his home. They went inside without a warrant. They located his firearms, and they took them just like that. When Edward came back home after his evaluation, which found nothing wrong with him, he asked for his guns back. Police told him they couldn't return them. He had been lied to. He had cooperated in good faith and got deceived in return. His legally owned property was gone and nobody had ever asked a judge for permission to take it. That's when Edward Kiglia did what every American should do when the government crosses the line. He fought back in court. He sued the police officers in the city, arguing that entering his home and seizing his guns without a warrant was a clear violation of his Fourth Amendment rights. The Fourth Amendment is the constitutional protection that shields you from unreasonable searches and seizures. In plain everyday English, the government cannot walk into your home and take your belongings without first getting a warrant from a judge. Edward's case was straightforward. No warrant was obtained, no judge approved anything. Police just walked in and took his property. Pause for a second right now. Do you think this ruling goes far enough to protect gun owners? Drop your answer in the comments below and tell me what you think. And while you're down there, smash that like button because it helps this information reach more gun owners who genuinely need to hear it today. The police in the city tried to defend themselves in court using a legal doctrine called the community caretaking exception. That's a legal phrase. So let me break it down for you right now in the simplest possible terms. Back in 1973, the Supreme Court decided a case called Katie versus Dombrowski. In that older case, the court said that police could sometimes search a vehicle without a warrant when they were acting as community caretakers, meaning they were trying to protect public safety rather than investigate a crime. Think about a situation where a car breaks down on a highway or an abandoned vehicle is blocking traffic. The idea was that cops shouldn't need a warrant every single time they open a car door for safety reasons. That logic made sense for vehicles on public roads. But here's where the trouble started and where it grew for decades. Police departments around the country took that car rule and decided to stretch it all the way to people's homes. They argued that if officers believed someone inside a home was in danger or might be dangerous to others, they could enter without a warrant and seize property, all under the banner of community caretaking. Lower courts in multiple states allowed this argument to stand. Gun owners had their firearms taken during mental health calls, during domestic disturbance calls, during neighbor complaint calls. There was no judge involved, no warrant signed, just an officer making a personal judgment call and walking out of your home with your guns in hand. Here's what this means for you personally, and this is the part that matters most in this whole video. The Supreme Court in Kiglia versus Stum said clearly and unanimously that the community caretaking exception does not apply to the home. Period. Justice Clarence Thomas wrote the majority opinion, and all 9 justices signed on. They said the home has always been the most constitutionally protected space under the Fourth Amendment, going all the way back to English common law before America even existed. Your home is not a car on a public road. It cannot be treated the same way, and police cannot invent a new excuse to skip the warrant process just because they think it would be easier or faster. This ruling draws a hard constitutional line right at your front door. So, what does this actually look like in your life starting right now? If police show up at your home because a neighbor made a call or a family member expressed concern, they cannot walk inside and take your firearms just because they believe you might be upset, even if they say they're just checking on you, even if they claim they have good intentions. Good intentions do not override your constitutional rights. You have the right to refuse entry. You have the right to tell them politely but firmly that you don't consent to any search, and that if they believe they need to enter, they need to go get a warrant first. That right exists today because of this ruling. This is like the difference between a friend knocking on your door and a stranger kicking it in. The knock you can answer or ignore on your own terms. But the moment someone walks inside without your permission and without a court order, they have crossed a line. And the Supreme Court has now confirmed with every single justice agreeing that crossing that line without a warrant is unconstitutional. Knowing that line exists changes everything about how you respond when police show up at your door for any reason that isn't a clear and obvious emergency. You are not powerless. You now have the full weight of a 90 Supreme Court ruling behind you. In just a moment, I'm going to reveal something about this ruling that even most gun rights channels and most Second Amendment advocates are completely overlooking. But first, are your notifications turned on? Tap that bell right now because the follow-up content on this topic is going to get even more specific and even more useful for your real-world situations. Let's talk about what this ruling means for the future, because most people hear a court decision and think it only affects the one person in the case. That thinking will cost you. Kiglia versus Stum sends a direct signal to every police department, every city attorney, every district attorney, and every state legislature in all 50 states. The signal is this: if you want to take firearms from someone's home, you need to go before a judge. You need to show evidence. You need to meet a legal standard. That process exists for a reason, and this court just said you cannot skip it. That creates accountability where before there was almost none when it came to warrantless seizures in the name of wellness. Here's what most people are missing entirely. Lower federal courts and state courts are now actively revisiting cases where guns were taken under the old community caretaking logic. People who had their firearms seized during welfare checks or mental health calls years ago may now have legal grounds to challenge what was done to them. It won't be automatic. It won't be easy. But the legal door is open in a way that it simply wasn't before May 17, 2021. If you or someone you know had guns taken during a police wellness or welfare check without a warrant, this ruling is the starting point for a conversation with a Second Amendment attorney. There's also something bigger happening here that directly connects to state red flag laws. Red flag laws, which are sometimes called extreme risk protection orders, allow a court to order guns removed from a person's home based on a petition, usually filed by a family member or law enforcement officer. These laws vary significantly from state to state. Some have strong due process protections built in, meaning you get a chance to respond before your guns are taken. Others are much weaker on that front. Kiglia does not strike down red flag laws directly, but it makes it much harder for anyone to argue that police can skip the court process entirely and just show up at your door based on someone's phone call. If your guns are going to be taken, a court has to be involved. That is the principle Kiglia reinforced. There is one more piece of the larger picture that you need to understand, and this is the part that connects everything. The Supreme Court's 2022 ruling in New York State Rifle and Pistol Association versus Bruin changed the entire legal test for evaluating gun laws across the country. After Bruin, courts must now look at whether a gun restriction is actually rooted in American historical tradition going back to the founding era. If a restriction has no historical basis, it is very likely unconstitutional under that new test. When you combine Bruin with Kiglia, what you have is a powerful 1-2 punch protecting gun owners. Bruin protects your right to own and carry firearms from government overreach. Kiglia protects your home from being searched and your guns from being seized without proper court process. Together, they are building something significant. Now, let's walk through 3 scenarios that are realistic and that gun owners across the country face regularly. These are not made-up situations. These are the kinds of calls police respond to every single day, and how you handle them could determine whether you keep your guns or lose them. First scenario, a neighbor calls police and tells them you've been acting strange, that you seemed upset recently, and that they're worried about you. Officers arrive at your front door. They're friendly. They say they just want to make sure you're okay and ask if they can come inside for a few minutes. What do you do? Before Kiglia, many well-meaning gun owners let them in, not realizing that once officers were inside, a legally owned firearm in plain view could be taken under community caretaking. After Kiglia, you can calmly and respectfully tell officers that you appreciate their concern, that you're fine, and that you don't consent to any entry into your home. If they feel they truly need to enter, they know how to get a warrant. That's it. That's the play. It's not confrontational, it's constitutional. Second scenario, a domestic dispute happens inside your home. Voices are raised, someone calls 911. Officers arrive while things are still tense. One officer asks you to step outside with him to talk while his partner goes inside to, quote, make sure everyone is safe. While inside, his partner sees your legally owned firearms on a shelf and decides to take them for safekeeping. Before Kiglia, departments routinely justified this exact move by calling it community caretaking. After Kiglia, that seizure is constitutionally suspect unless there was a genuine and immediate emergency that justified skipping the warrant process. You have legal options now that gun owners in the same situation 5 years ago simply did not have. Document everything. Get an attorney, use this ruling. Third scenario, you go through a genuinely rough stretch of life, maybe a divorce, maybe job loss. A family member calls a non-emergency police line and tells them they're concerned about your mental state and your access to firearms. Officers show up at your door. They explain that a loved one filed a concern and they'd like to take your guns temporarily just until things settle down. They frame it as the safe and reasonable thing to do. This is where Kiglia is most directly powerful. Without a court order and without a warrant and without a true life-threatening emergency right in front of them, police do not have the constitutional authority to enter your home and take your property. You can decline. You can stand on your rights. And if they take your guns anyway, you now have a landmark Supreme Court ruling at the foundation of your legal case. Now let's deal with the myths because they are spreading online and they will get you into trouble if you believe them without understanding the full picture. The first myth is that means police can never take your guns from your home without a warrant under any circumstances. This is wrong, and believing it could seriously backfire on you. There are still recognized exceptions to the warrant requirement under the Fourth Amendment. Exigent circumstances, which means true emergencies where someone's life is in immediate danger right now, can still justify police entry without a warrant. If you are actively threatening someone with a firearm, if there is a hostage situation, if a life is at immediate risk inside that home, police can and will act without waiting for a warrant. Kiglia closed the community caretaking loophole. It did not eliminate every tool law enforcement has in a genuine crisis. Know the difference between a real emergency and a manufactured excuse. The second myth is that this ruling automatically gives you your guns back if they were taken under community caretaking before 2021. This is wishful thinking, and acting on it without legal help could hurt you. Supreme Court rulings establish precedent, which means they guide future cases and reopen the door to challenging past ones. But that challenge does not happen automatically. You have to take action. You have to file in the right court in the right way within certain time limits. An attorney who specializes in Second Amendment and civil rights law is the person you need for that conversation. Kiglia gives you powerful legal ammunition. It is not a self-executing order that returns property to every gun owner who was ever affected. The third myth is that the Fourth Amendment protects you equally everywhere you go. This one trips people up all the time, and it matters enormously for gun owners. Your home gets the strongest Fourth Amendment protection under the law. The Supreme Court has said this repeatedly across many cases going all the way back more than a century. Your car gets significantly less protection. A public sidewalk gets even less. Kiglia doubled down on the principle that the home is the castle. That's not just a saying people use. It is a legal principle with constitutional force behind it. So don't make the mistake of assuming that because your home is now better protected, you have the same rights when police ask to look in your car at a traffic stop. That is a completely different legal situation with completely different rules. Let's bring this all home now, because I want you to walk away from this video with 3 things permanently locked into your memory. The first is the name and the number. Kiglia v. Strum, the Supreme Court of the United States, May 17, 2021, 9-0. That vote count represents every single justice on the court agreeing that what happened to Edward Kiglia was unconstitutional. That is not a close call. That is the entire court saying this was wrong. 9-0 is as strong as a ruling gets, and that strength matters when you're standing at your front door trying to remember your rights. The second thing to lock in is the practical principle. Your home is a constitutional fortress. The Fourth Amendment protects it. The Supreme Court has now reinforced that protection unanimously by rejecting the community caretaking exception as it applies to homes. Police need a warrant to enter your home and seize your property unless there is a genuine life-threatening emergency happening right now. Your good faith cooperation does not waive that protection. Your neighbor's phone call does not waive that protection. A family member's concern does not waive that protection. Know this. Say it out loud. Your home requires a warrant. The third thing to lock in is the bigger pattern. Kiglia is not an isolated event. It is part of a line of Supreme Court rulings that have been steadily reinforcing the constitutional rights of gun owners. Heller said you have an individual right to keep firearms in your home. McDonald extended that protection to every state. Bruin said gun restrictions must be historically grounded or they fall. And Kiglia said the government cannot create workarounds to strip your guns without due process. These rulings build on each other. They form a framework. And the more of that framework you understand, the harder it is for any government actor at any level to intimidate you into giving up what is legally and constitutionally yours. Here's why all of this matters for your family and for the long game. Rights don't usually disappear overnight. They disappear slowly through 100 small exceptions and 1,000 quiet workarounds, each one sounding reasonable on its own. Community caretaking sounded reasonable. Temporary safekeeping sounds reasonable. Good intentions can always be used to justify almost anything. What protects you from those quiet erosions is knowledge. Knowing the name of the case, knowing the vote count, knowing what the court actually said. That knowledge turns you from someone who can be managed into someone who cannot be pushed around. And that is exactly the kind of citizen the Second Amendment and the Fourth Amendment were written to protect. If you made it this far, you're serious about understanding your rights. Subscribe right now and turn on all notifications. Legal updates are dropping constantly, and you need to stay informed. Drop a comment below and tell me, have you or anyone you know ever had firearms taken during a welfare or wellness check? I read every single comment, and I want to hear what happened to you.